Hey everybody, this is Mark Levine, and you're listening to the 25th episode of the NYC Real Estate Podcast. We're doing things a little bit differently today. We're all working remote because of the COVID situation, so we're actually taping this on Zoom, and then we're going to upload this to hopefully YouTube and also to the podcast app, which you may be listening to it now. And I have as a guest today Julie Schechter from Armstrong Teasdale. Hey, Julie.
Hi.
So it took you 25 episodes to finally get on the podcast. I wrangled you because you have nowhere else to go.
Well, thanks for having me. So I couldn't use the excuse that I had a prior commitment today because nobody's leaving their house.
So you're an attorney and you do a lot of business or a lot of dealings in real estate, specifically co-op and condo, right? And rental buildings, I'm assuming for landlords as well. Do you want to give a little background on yourself and how you came to be at your current position and what you specialize in?
Sure. I am a partner at Armstrong Teasdale, which is a national law firm. I'm based in the New York office, and I'm one of the partners in the co-op and condo department. Our department is part of a larger real estate department, but our co-op and condo department has about 13 or 14 attorneys that do exclusively co-op and condo board representation. We represent over 400 co-op and condo buildings in New York City and the outer boroughs. And that's pretty much what I do day in and day out, is advise boards on corporate issues.
So out of those 400, how many are you involved in? You touch a lot of those?
I do. So basically our firm does it a little bit differently than other firms which have one attorney per building. We all work together on every building. So I know the majority of the boards on our buildings, and I've worked with them in one capacity or another over the years. I've been practicing for over 10 years, and most of our clients have been clients for longer than that. So I've had the benefit of working with most of the buildings a handful of times at least.
Oh, very cool. So how are you guys right now? We're all remote. Everybody's remote. We're all set up at home. I think some of my...
Well, I am reporting to you live from my living room. So
I like the wallpaper. It's very nice.
Thanks. Yeah, well, I should say it's my parents' living room.
I'm assuming everybody in your office is also working remote and social distancing and keeping everybody away from each other as much as possible, right?
Yes, we are.
So obviously we're managing buildings, you're representing buildings. We have the luxury of staying home, but a lot of the employees of those buildings, whether it's a super, a porter, a handyman, those are considered to be essential service employees, and they're on the front lines, if you will. Obviously they're not healthcare workers, but they are subject to more possibility of having some sort of contagious disease fall upon them. So what we're doing is we're equipping everybody with as much PPE as possible, protective equipment, and also disinfecting as much as we can in terms of our call buttons and the elevator buttons and any common spaces that are touched, like the laundry rooms. And I'm going to go through that all kind of in what we're going to talk about today. But where we have the luxury of working from home, they don't. So we're always very
exactly.
They still come into work, and it's amazing. And they're doing the best that they can given the tools that we give them. So I guess it's right now broken down with essential services and not essential services. Management, I think back office could be construed as an essential service. We're working, but we're working from home. My office actually is structured that if we wanted to have everybody come in, we could, because basically everybody has their own office in my office, and there's really no common areas. There's more than 6 feet where there is somebody in two people in one office per se. They're more than 6 feet apart and they're not touching each other. So, but we've chosen to just have everybody work from home, and only my partners go in every so often to collect the mail and send it. We actually drop it on the doorstep of certain employees that have to have their mail, and it's no contact.
Well, I agree with that. Our office, although everybody hangs out in the kitchen, our office is set up for social distancing if need be. But another concern of ours was, how is everybody going to get to work? And most people need to take public transportation to get there. And so that's what we didn't want people doing. And so closing the office made the most sense to, prevent people from having to take public transportation at this time.
It's a short-term problem, but it's a long-term, hopefully keep everybody healthy. And
That's right.
yeah, and
That's
money
right.
is one thing, but health is, if you have all the money in the world, it doesn't matter. But if you don't have your health,
You've got nothing.
got nothing. So real estate brokers are considered to be essential.
Yeah, I'm not quite sure why. But yes.
I think they're scared of the economic meltdown that would happen if sales and leases can't be signed and can't go through.
Yeah, I think it's definitely driven by economic desire to keep the market going. But when this all happened, and they defined what essential and non-essential services were, developers, people who are building buildings were originally considered essential, and they were allowed to continue to work. But there was an interesting article in the Real Deal about how active work sites were, the COVID-19 was spreading like wildfire, because even though people were working outside, they were working in very close quarters.
Right.
And, I saw Governor Cuomo on the news, and he said he really regretted that decision. And a couple of days later, he switched it to a non-essential service, and all construction services were shut down with very few exceptions. So,
I'm going to go through those a little bit later too. So,
I was jumping ahead. I was overeager.
You haven't seen my notes. It's fine. So even though real estate brokers are considered to be an essential service, we're still recommending that everything be done as much as possible through digital means. The buildings, we've told every building that we manage, they shouldn't allow any open houses at all. Everything, if it needs to be shown in person, it has to be by appointment only. It has to be approved by management, because we have to take the extra step to make sure that everything is disinfected and people are properly outfitted, to make sure that they're keeping as safe as possible. The residents in the buildings don't want unknown people in the building. It's one thing surrounded by 400 apartments, and you don't know where everybody's going. There's obviously a lot of people that work in the health field, so they're coming and going, they're taking their precautions. But somebody off the street, it's just another chance for something to happen. And Redney's also come out and said, if anything, it should be done through video walkthroughs or FaceTime.
Right. That's a point that I was going to make. A lot of the brokers are coming into a building, doing one walkthrough with their cell phone, doing a simple iPhone recording, and then you have, there you go, a virtual walkthrough. They're putting them up on the websites, on Douglas Elliman's website or Corcoran, whichever brokerage they work with, and then people from the comfort of their own home can view an apartment without endangering anyone in the building, without allowing for open houses. And the only risk on the building is allowing one broker in one time. So a lot of buildings are allowing that, and it seems to be a safe decision that still allows for sales and showings to go on. So it seems like a pretty good solution to me.
Yeah, I think it's hard, but it's better than nothing.
Right.
And it's going to be the new normal for a long time. So people better get used to it. But,
yeah.
All right. So I talked about how we disinfect for the staff, what protocols we have in place. The staff is frequently disinfecting, and we're taking care of all the surfaces. It could be front door handles, it could be apartment door handles, it could be the elevator buttons, the laundry machines. But we're also advising everybody to use something that could become a barrier with touch points, like use a disposable tissue or napkin to touch the buttons and then throw it away. That'll stop basically people from, just touching everything and spreading it all over the place. And, we have some buildings that have obviously the disinfecting in the lobby.
If you could get your hands on
well,
Purell, then we're recommending to put it in the lobbies, but it's become contraband. It's hard to even get your hands on it.
I know, personally, you see how hard it is to get anything. And then every day I have boards saying,
oh yeah, I believe
getting us this. I'm like, if you can find it for yourself, we've got multiple orders out. If you can find it for yourself, that's amazing. Tell me where you could get it, because we're going through every channel plus some that we've never used before.
Although there was a recipe online that I saw for making your own hand sanitizer if all else fails.
Yeah, I think it was like aloe vera
and rubbing alcohol and
essential oils. Yeah.
Yes.
Yeah. We haven't gotten that far. I did for one building that of in Brooklyn. I ordered, I think, 100 16-ounce bottles of iso alcohol. and aloe vera, but it hasn't been shipped yet. You know, it looked good until it came out to be like, oh, it'll be there in 2 months.
Right, exactly. Right when the pandemic's over and you don't need it anymore.
Exactly. So we're also saying don't congregate, you know, keep your space in the common areas. If you're doing laundry, don't hang out in the laundry room, put it in, go upstairs, come back down, just try to.
That's exactly right. And very early on in the process, what we advised a lot of our boards to do was to close common areas altogether. You know, the governor came out and said that gyms are a non-essential, non-essential service, and all of gyms in New York were closed. They're based on the language of the executive order. There was some confusion as to whether he meant commercial gyms only or commercial and private gyms, but our recommendation to the boards was just to close them. There's no reason why someone should be sweating on a treadmill and someone should be on the treadmill next to them. It's just a very easy way for the virus to spread. And we were recommending people, even though everybody has a right to the gym that you bought, knowing that you had the gym, we're asking for people's understanding, and we're closing the gym to protect everybody. And our position is that boards who are responsible for the health and safety of the shareholders or the unit owners have, in a case like this, have the ability to do that if it's in the best interest of everybody. And we really believe at this time that it is. But another important thing.
Oh, sorry. I won't step over you. You finish.
No, I was just going to say, if a board wants to protect themselves from liability after this is all over from somebody claiming that they absolutely were entitled to access to the treadmill and that they were deprived of that, is we're reminding boards to follow corporate policy. And if you're going to make a decision on behalf of the board, that decision should be formally recorded in a resolution, and that should be reflected in the minutes of whatever meeting it was taken at. And that way, if a shareholder down the line wants to object to any of the board's actions, at least you will have formally adopted a resolution agreeing to close down the gym, for example. One thing that we did mention to a lot of our clients is that management companies a lot of management companies took the lead on that and just sent out memos saying we're closing the gym, we're closing the community room, without really consulting the board, just because that was their management company's policy. And we completely support all of those decisions, but one thing that a board could do to formalize that is just have a meeting and all vote in favor of reaffirming the memorandum that went out from the management company as to closing the gym or closing the community room, or any of the steps that were taken in a memo that was distributed from management. And it's a simple way of making sure that the board confirms all of those decisions that were initiated by management.
And one thing that we could also impress upon them is it's great for you to be able, as a unit owner or a shareholder, to use the gym, but why don't we protect the staff members who have to then go in and clean it?
That's another great point.
Yeah, it's one less place for them to have the possibility of getting sick while they're at work. And we want to create a healthy, establishment for them to come to every day.
That's right. The laundry room is a little bit of a different story because people need access to the washers and dryers. But one thing that we've done is many laundry rooms in residential buildings have limited hours. Like, for example, they open at 8 a.m. and close at 6 p.m. or close at 8 p.m. We've told buildings to just keep them open 24 hours. And hopefully that will help disperse the crowds in the laundry room. Maybe someone will want to do their laundry at 11 o'clock or at an odd hour when they think they won't encounter anybody. And so we definitely recommend that boards do that. Another thing is we've put a bottle of Clorox wipes or Lysol wipes in there, and we've just asked people to respectfully wipe the machines after they use them. So that way we don't need to devote our building staff's attention to cleaning the laundry room every half an hour, because it's not a good use of our resources. And as you said, it's not really fair to ask them to be constantly doing that and putting themselves at risk.
And you could also, we've seen buildings that we have where they've, just like Trader Joe's would say, between the hours of 9 and 10, it's for the elderly to come in and shop.
That's a good idea.
Have maybe a 2-hour window where it's just for residents of a certain age group or that are worried. I'm not discriminating against anybody, but anything that we could do to, ease that burden on the.
Yeah, no, I haven't heard that as an idea, but that's a great suggestion.
Mark it down and you can tell everybody it came from me. What's your take on moves? you know, we have a lot of people, oh, I have to move out of the apartment. I want to move into the apartment during this crisis. Is that considered to be, in your opinion, an essential service?
Well, so according to the governor, residential moves are essential. And so the residential moving companies can continue to work. You know, I feel a little bit differently about that. The movers are in and out of residential units and residential buildings, and coming into close contact with one another every single day. And so they seem likely to be good transmitters of the virus. So I guess my advice to buildings has varied depending on the layout of the building. Some buildings, it's possible if there's an elevator that they can devote only to moves, and if you don't need to walk through, like a service elevator, for example, and you could come in a separate entrance of the building and not walk through the lobby and use only that elevator, then I feel a little bit differently about allowing moves, because it seems like the risk is minimized as much as possible. Alternatively, if you have a building where there's, for example, one elevator, then you're going to need, shareholders or unit owners are going to need to be using the elevator during the time when the movers are coming. And I don't think it's fair to ask them to do that, especially if they're concerned about the health of the movers. You know, in cases where the movers can move without really affecting the shareholders, we've, you know, the buildings that have that situation have been allowing moves, but one thing that we've recommended that is possible is asking the buyer and the seller to each pay an extra $250, and then that money goes to an extra cleaning fee of the elevator to make sure that, you know, of the elevator, the doorway, the door handles, you know, just to make sure that everything's sanitized after the move. We've also required moves to be completed within a certain number of hours. So, you know, all moves have to be completed within 2 hours just to free up the elevator and get the people in and out, you know, get the movers in and out. But it's a definite concern for buildings that have only one elevator or have elevators where you need to walk through the whole lobby. And a lot of them have stopped moves altogether. And whether or not there'll be liability from a seller who potentially loses a deal because we didn't allow the move, you know, only time will tell. And unfortunately, no one's going to get in front of a judge until after this is all over and the decision has been made. So we're not going to really have an answer to that until it's too late. But it's a tough decision, and there's no great answer to that question.
Would it help if we had the movers wearing PPE, wearing masks, wearing gloves, you know, disinfecting the elevators, coming in, going out? Do you think that would help to offset some of the risk?
I definitely think it would help. A lot of the movers that I've seen have come themselves with PPE for their own protection. But, you know, one of the concerns is that PPE isn't always used right. You know, that the masks are not protectant enough, that the gloves are not taken off frequently, and that they're used, you know, that the gloves are essentially contaminated because they're touching new things, they're touching old things, you know, they're used for multiple moves because PPE is so limited, it's hard to get your hands on it. So while I definitely think it's a good idea to have the movers use it, you know, how effective it is, I can't tell you.
You brought up a good point about elevators and how they're used. And one of the memos that we sent out to a lot of buildings has, you know, with the social distancing being the way that it is, just trying to limit the amount of people in any elevator at any given time. So if you are in the lobby and somebody wants to go up to floor 7, you're going to floor 9, maybe you just wait until that goes up and comes back down so you could go up alone. This way you prevent having to be on top of somebody else.
Yeah, that's a great idea. Another idea that I've seen is we've had painter's tape put down in the lobby 6 feet from the doorman so that people know to stay beyond the line, and that way the doormen feel comfortable coming into work every day, because as we all know, people go very close to the doorman, lean on the, you know, lean on the furniture and want to get close. And a lot of the doormen felt uncomfortable being in such close contact, but unfortunately they can't leave their post. So we did that as a reminder to the shareholders to keep a safe distance. I've seen a lot of reminders, which I agree is great advice, to you should only be in the elevator with your family. If you see someone else in there, let them get out before you get in, or ask if they mind if you get in. Of course, all of these things have to be that we're respectfully suggesting that you do it. None of these things can really be required, but I found that most of the residents are adhering to the, advice that we're giving.
And
I think everybody wants to protect themselves.
I would hope that they don't want to
get it either.
Yeah. So this is really something for you to kind of walk us through the let's say we have a resident or either resident or a staff member who test positive, they alert management. Disclosing information to not, what information do we disclose in those cases to residents and to other staff members? Because obviously there are privacy protections. Not that we're bound by HIPAA guidelines because we're not medical in nature, we are operating buildings, but let's say a resident tells us, oh, I've been tested positive, I'm self-quarantining. What do we do? How do we get the word out that maybe somebody in your neighborhood, in the building has tested positive without flagging who that person is or giving up any privacy?
Right, exactly. So those are big concerns, and we've been advising our boards not to reveal any identifying information. So obviously don't reveal the shareholder's name. We've also been saying not to reveal their unit number, and in most cases not to even reveal the floor. I have one building that has 4 units per floor, and they were insisting upon revealing the floor number of somebody who had tested positive, and we said that that was even giving too much of a hint. Right. And that we recommended that they did not reveal the floor number. What you want to do, if you have somebody in your building who's tested positive, is to let the other shareholders or unit owners know that there's somebody who tested positive. But then just simply remind people to follow the CDC's regulations, continue social distancing, wash your hands frequently, stay in your apartment as much as possible. Because the truth is, the guidelines would be very similar even if you revealed who had it. Those are the recommendations that they should be following, regardless of whether they know who was identified, the positive person was identified. But one of the things that I want to point out is if you were to reveal the name of the person who tested positive, one concern of somebody else who may test positive in the future is that they may be nervous to come forward because they don't want their name to be revealed. And so the last thing a board wants to do is blow up somebody's spot and then not have the next person come forward because they're afraid of their name being revealed. And from a management standpoint, you want to know who has it. And so you don't want to prevent people from feeling comfortable coming forward.
That same argument that I used to have about bed bugs.
That's right, same thing.
Tell us, we won't tell everybody who has it, but we have to do our inspections after bed bugs, hit. But if we tell everybody who had it, nobody's going to come forward. It's the exact same thing with this. Okay, so we cover the residents. Right. Staff member gets sick, they have it, or they're assumed to have it. Not everybody's getting tested because right now we're filming this on April 9th and not every test is available for every person. So the staff will probably catch on who of the staff is out and are they having an issue. It may need to be disclosed in some form or fashion or not. You tell me, to the residents, that your super who's been throughout the building for the last 2 weeks test positive. How do we handle that notification? Or do we not, or do we just say that they're out with, they're out ill and they'll be back as soon as possible?
Well, one thing that we've done is asking the employee if they mind if we reveal their name. I mean, unlike other types of diseases, which could be embarrassing or which you might really not want people to know, this anybody can get and most people are going to get. And so it's not, there's not as much of a social stigma as there is for other diseases. And so we've been asking employees if they would mind if we if we reveal their name, or if they can give us a list of places they were in the building or people that they came into contact with, just so that we can let those people know, or just, extra sanitize those parts of the building. We've made sure to get written consents from anybody who's agreed to allow us to reveal their name. But every staff member that we've confronted and asked for their permission, they've given it so long as we can get in touch with them. In 1 or 2 cases, we had people in the hospital who, were not in any position to consent. But most people want people to, what I have found in my experiences is most staff members want their fellow staff members to know, because they want to try to limit the spread as much as possible. And so we haven't really gotten any pushback on getting a written consent to reveal their names.
Okay. All right, so let's move on. So emergency work is one thing. Non-emergency work is any renovation going on in an apartment, something that's cosmetic, that's cut off. So we're only doing emergency work. We're only doing emergency repairs too. So if somebody calls the office and says, I have, a slight drip that's not turning into a big issue, that's not considered to be an emergency right now. But we're telling our residents that should a staff member have to go into the building, or into the apartment rather, that we may ask that resident to leave the apartment during that visit to limit the face-to-face interaction, and they'll also be wearing PPE. So that's just something that we're doing. We were talking a little bit before we started about the payroll protection programs and SBA loans. So there was a lot of confusion, I know, when that came out, that said that you had a really in-depth, I stopped you, I know. 10 minutes in, I stopped you. I'm like, wait, we'll talk.
I could talk forever, so sometimes I need people to stop me.
So do you want to walk us through the PPP loan, and also whether or not buildings are eligible based on what we know today on April 9th?
Yeah, absolutely. So under the CARES Act, a program called the PPP program, Payroll, Mark, help me out here. Payroll
Protection Program.
Payroll Protection Program was created, and this was to provide money to small businesses to allow them to keep their payroll, to keep their employees employed, and to stay above water at this time. Part of the issue with the program was that when the original PPP program was drafted, it was extremely broad. The only restrictions on who was eligible for funding were that you couldn't have over 500 employees, and that you had to be a for-profit business. A week later, or maybe not even a full week later, additional regulations came out, and additional changes to the PPP application came out. And then suddenly there was a lot of confusion as to the eligibility of co-ops and condos to participate in this program. Part of the issue was that the Small Business Administration was appointed to be the people who distribute this money. And the SBA has a longstanding history of giving small business loans under existing regulations that they have in place. Now, what happened was, for the PPP program, they decided to attach existing SBA regulations onto the PPP program, but they weren't an exact fit because they weren't custom tailored to the PPP program. So suddenly we have a program, now we have existing regulations which were tacked on, and there are naturally gaps and conflicts and inconsistencies between the two documents because they weren't ever intended to be used together. And so now it made sure that all of the lawyers had a lot of work to do, and all of the accountants trying to figure out whether or not any of these rules were even applicable. And so that's where we are now. Part of the issue is on the application, it asks the applicant to certify that they're eligible for the loan. And your guess is as good as mine as to whether co-ops and condos are actually eligible. So a lot of lawyers are telling their clients, don't sign that certification because we don't know if you're eligible. And that's definitely the most conservative approach. The only problem with that is by time, REBNY and a lot of attorneys are writing to Congress people and trying to get clarity as to whether or not co-ops and condos are eligible for PPP loans. But the problem with waiting until the regulations are clarified is that there's a finite amount of money under the PPP program that's going to be allocated to small businesses. And so businesses have until June 30th, or until the money runs out, to apply. And our fear was that if our clients wait until the regulations are clarified, and they may never be clarified before June 30th, that the money may run out before they get a chance to apply. So one thing that our firm thought was a good idea was, under the SBA regulations, it allows you to submit an eligibility statement or a waiver if you're not sure whether or not you're eligible. And so our recommendation to our clients who desperately wanted to apply now and not miss the opportunity for this funding was, if you want to apply now, apply with this eligibility statement, which we've drafted for our clients. It basically states why under the regulations we think they should be included. And then at the end, it asks for a waiver if it turns out that they're not included. And the last part of it is that it says that the certification in the application, which states that you're certifying that you are eligible to apply for this, is all subject to the terms of the eligibility statement that we're including in the application. So that insulates board members from liability in case it turns out that they're really not eligible for what they're applying for.
Have you found clients have been applying for that just in case?
Well, so that's an interesting question, and our clients have been all over the map. We have, for example, I have one client where they have 7 commercial tenants. And as you know, the governor has restricted, retail. Everyone that's not essential, their stores are closed. So we have a nail salon, and we have a cosmetic store, and a bunch of stores that are not open for business right now. And so they have no income coming in. And in turn, they're not paying their rent to the co-op. And they pay a significant amount of rent. It's a strip of stores in Chelsea. And so the co-op's income is going to be heavily affected by the fact that none of the commercial tenants are paying right now. And so they're in a much different position than most co-ops. They really need the relief. And so for a building like that, they felt like they couldn't miss this opportunity. And if there was any money to be available, they wanted in. And so they are going to apply with the waiver. And this applies for a lot of buildings. A lot of co-ops own parking garages, which haven't been paying, or own other retail stores and are in a similar position. There are also buildings where residents have stopped paying. And April 1st was the first payment date. Where rent was due since this pandemic started. So maybe everybody, maybe shareholders on April 1st are still able to pay, but as layoffs become more prevalent and as, more companies are furloughing, we're going to see it becoming more and more difficult for shareholders to pay their rent come May, come June. And I hope it doesn't go further than that. We also have some buildings, we have some very fancy buildings on Fifth Avenue or on Park Avenue who've told us that they felt ethically that it was, just morally wrong for them to be applying for money, knowing that there's a finite amount of money to be distributed and that the money was only going to be distributed until it was exhausted. And they felt like a fancy building on Fifth Avenue didn't need the money as much as the pizza place down the street, which would be forced to close if they don't get a loan. So, we've seen the gambit, some buildings ethically recusing themselves from applying, other buildings hot to apply and get the money as soon as possible. And so it really depends on your board's needs. And that should be one of the guiding decisions. Other boards have simply said, listen, it's a very low, most of the loan is going to be forgiven, if not all of it. And for that part that's not forgiven, it's a 1% interest rate, which is basically like free money. So if we can qualify, let's do it. And so there's a large spectrum of what clients feel is appropriate, but each board needs to make that determination for themselves.
So you kind of split into my next topic, which is on
Look
March,
at that.
and you don't even know.
I'm so good. I'm that good.
On March 16th, all eviction proceedings were suspended in New York City. So basically right now, housing courts are operating only on an emergency or essential case basis. And the template for that is basically landlord lockouts, serious housing code violations, and requests for emergency repair orders. So based on that, that's an important discussion to have, because there's non-payment, which some buildings are going to apply for a loan on. And I'm going to get into like the the loss of the business interruption loss also that we could file for, maybe. But we're seeing a loss of revenue, potentially handcuffing a lot of buildings. It's a double-edged sword. You know, you want everybody to be able to live in their home, but you also have to run a building. You know, you have to pay rent.
Absolutely.
So some people, I'm on some Facebook groups, you know, in the New York City area. I won't single out some, but I saw some that were like, oh, great, you don't have to pay rent. But that's not true. You still have to pay rent, because even though you can't get evicted, we could still.
The rent is due.
Rent is due.
Yeah, I actually saw a bunch of those chat rooms too, and I wanted to weigh in, but I didn't want to be the Debbie Downer on the chain of everybody thrilled not to pay their rent. So I just read them and moved on. But yeah, that's absolutely right. The rent is still due. Right. Just because you can't be evicted doesn't mean you don't own it, and it doesn't mean you don't owe it.
Right.
And so maybe.
And you're still doing the paperwork to get to that housing court action when it starts up again. It's not that it's.
That's right. And liens can still be filed against condominium units. And so they don't get a free ride either.
Yeah. So there's two important points about just COVID related. So landlords can't lock out or evict tenants for having COVID-19, and they can't ask you to leave. And you can't be discriminated against for fear of having it or being on home confinement or anything related to that. So you're adding that, just it's a discriminatory function. You're as a landlord, you're not allowed to do that to your tenant. So if you feel that you have COVID-19, if you've tested for it, nobody can knock you out of it. They can't move to evict you. They can't harass you. You have complete freedom to live in your apartment under the guidance of your doctor and home confinement and keeping social distance.
Exactly. And when you look back on the governor's orders, on the executive orders and the order with which they came out, putting a freeze on evictions was one of the very first ones. And it's important because in order for all of the other relief to take place, there's a lag in time. They can only get the money out to small businesses. Everybody can only apply so fast. They can only get funding so fast. And so preventing people from being evicted while the government's getting money distributed is very important, because they want to make sure that people, they want to make sure no matter what, that people are able to stay in their homes. And so if it takes a couple of months for government relief to be distributed, then the thought process is once people have money back in their pockets and businesses reopen, it would be unfair if they had been evicted in that time. And so evictions won't commence again until a lot of the government funding has been redistributed and until the restriction on operating businesses has been lifted to make sure people have money.
Do you want to talk about how we're kind of operating? Me and you were both working from our own separate homes, but board members are also working from home. They're not meeting in person anymore. They shouldn't be in the same room together. I've gotten a lot of, May is like heavy annual meeting season, but for you,
that's right.
For me, I mean, if for some reason all the offering plans were drawn up that the bylaws call for, like the second Tuesday in May, and that's like
right.
Every building, I don't get it. So
it's because they all copied the same form.
I know, but there's only one of me and there's only one of you. But
that's right.
50 buildings.
It's a very busy Tuesday.
It is. So we're doing Zoom meetings with all of our boards. And I think it's going to change the landscape of how we operate in the future too, because we can get so much done.
Yeah, it's great.
I had a board meeting the other night, and it was two of us it was me and one of my property managers, Phil. And we had a 2-hour board meeting with all the board members on Zoom, and they had questions, and I'm not sitting there in the board meeting my standard response is, if I don't have the answer for you at the board meeting, I'll email you tomorrow. Every question was answered almost 30 seconds behind real time, because I'm sitting at my computer. I could log into my software. I could look through my emails. I could pull up the PDF. So,
yeah, it's been great.
Yeah. So
it's also easier to get everybody on a Zoom call than it is to meet in person. Sometimes if people are traveling, people don't, necessarily live in the building as their primary residence. They live elsewhere. Everybody can call into a Zoom. So we've been getting much better attendance at board meetings. Also, nobody has anything better to do.
Yeah, but sitting at home with nothing to do.
Well, that definitely contributes to it. But But yeah, I have a feeling moving forward, Zoom conferencing will be used much more frequently for boards, especially boards that would meet less frequently because they couldn't get everybody in the same room.
Yeah, and there were some security issues with Zoom, and the only 2 points of information that I gave to everybody is just password protect your Zoom conference, so people have to dial a password. And I'm recording this now. If you record the Zoom, record it to your computer. Don't record it to their cloud server, because that has a potential to also get hacked a lot more easily than, it's going to my computer, and then I put it in my Dropbox, which is my Dropbox, and hopefully it's encrypted. It won't have a problem. So what are we thinking about annual meetings that are going to be postponed? Where either maybe for smaller buildings or medium-sized buildings, it may work to do it as long as it's laid out properly on Zoom, or we can have everything sent out by postal mail and do mail-in ballots, or we can have, the different procedures than we were used to. But if it doesn't specifically say for a lot of, let's say the 1960s, 1970 boards where, the bylaws where computers really didn't exist in this form or fashion, like what's the status of saying, okay, let's do it digitally, and I think the New York state law, didn't it switch late last year to allow just New York business corporation law to allow online meetings as long as you could prove that the person is who they say they are, that they can go forward?
That's right. So there's a size fits all answer to this because every building is different. It's very different to have a 1970s co-op with 1,000 units in the middle of Brooklyn than it is to have a new construction 30-unit condo in Williamsburg. Whereas a 30-unit new construction condo in Williamsburg, most likely the unit owners will all know how to use Zoom or will be able to call in for a conference call. In a 1,000-unit co-op that was built in the 60s or the 70s elsewhere in Brooklyn, it's not going to be all young people. It's not going to be all tech savvy people. It's not going to be people who have the capacity to even call in for a conference call. And under the business corporations law, if you want to have a meeting like that, everybody has to be able to hear one another. And so our recommendation to all boards is to postpone. And there's no reason why the annual meeting needs to be the second Tuesday in May, even though it says that in the bylaws. Courts have held that really just is a general date, and you should endeavor to do it as close to that as possible, but that there's no, it doesn't exactly have to be on the date that it says in the bylaws. And for most boards, delaying it and hopefully being able to do it in person in the fall is the best option, because you're going to guarantee that everybody has an equal ability to attend the meeting. And if you were to do it by Zoom conference, for example, people who didn't have computers or who didn't have smartphones may be prevented from joining, and that would be the worst case scenario, far worse than putting off a meeting and having it a couple months later. The business corporation law also has a provision for if a meeting is not held or if it's held and there is no quorum, which means that you can't vote for new directors. And the language says that the existing directors will continue to serve until the next annual meeting or the next meeting, I should say, where they're voted onto the board again. So even though under the business corporation law, there should be an annual meeting held every 13 months, if we're unable to do it, the existing board members, if they want to, will continue to serve until the next meeting where there's a board vote.
Okay, and what about by paper? If we're sending out a notice of annual meeting that doesn't state the time and the place, but it states the date of the vote with ballots, and if you want to run for the board, send a note to management by such and such date, and then a ballot goes out in advance of that date for people to fill in and mail in. Maybe there's a ballot box in the building that people could have it stuffed, even though I wouldn't want to touch all of those ballots at this point. But is that a viable option for buildings to do it by paper?
Well, so what we've been asking boards is, what is your goal for wanting to have the meeting now? If the goal is we really want an update on the financial status of the building, our recommendation is, okay, let's speak to the accountants about getting an audited financial statement and still circulating that regardless of the fact that we've postponed the annual meeting. Other boards have said we want to do it because it requires it under our bylaws, which we just discussed. And then there are a couple of boards that say, well, we want to vote for new directors. And if that's the primary goal, then we can work out something. Again, it depends on what it says in your bylaws. Some boards are able to do it, with nominations before the meeting. It may be possible to amend bylaws or to pass a resolution, which would allow for that type of meeting. It's very building specific, so you have to speak to your lawyer about that. But if your notice of meeting has very careful instructions, it's possible to do that. Have everybody nominate themselves before the meeting, then do another mailing, which would list all the nominees and have everybody fill out a proxy, and we can vote by proxy. But another problem and a reason why I'm asking boards, advising boards that they're better off postponing than doing it that way is a lot of people left the city. People didn't want to be in multiple dwellings, and so they went to country houses, or they're living with friends or parents or children outside of the city. And so you would hate to, mail letters to everybody's apartment and have only 50% of the people be able to respond to it because they're actually in their apartments to receive the mail. So even mailing it may be an issue as far as getting quorum and getting access to the residents.
Yeah, I could see where if you have a complete building email list that's verified and you could send out a Google form that has to be specifically signed by that email address, maybe they only have the link and it's verified, maybe that's a way for a ballot to go through.
Yeah, absolutely. And I have a building, like I said, a small condo in Williamsburg where we have email addresses from everyone. And I think what we're going to do in that building is have everybody send us an email saying that if you receive, we're going to give them language to send back to us, but it will say something to the effect of, if you receive an email from this email address, I certify that it's me, and you can accept that as a vote. Anything that comes in, it will be as good as if I had given it to you in person. And then we are going to do it by emails. Another thing to note about proxies is even if you circulate a proxy by email or by mail, under the law, there's no requirement that form be the proxy that's submitted back to you. So if somebody put into an email, I nominate so-and-so as my proxy and here is my vote, even the email would be sufficient to constitute a proxy under the law. Mm-hmm. It's not necessary that they have a scanner and they scan back to you the exact form that you prepare.
Yeah, and we have a lengthy history over directed proxies and non-directed proxies, general proxies. So yeah.
Yes, we do.
Lots of types of proxies out there. Kind of jumping back to financials a little bit, the mortgage protection. The CARES Act provided that a borrower with a federally backed mortgage can request a forbearance without penalties, fees, and interest for 180 days. And then on top of that, if the borrower requests it, they could have another 180 days at the request at that time. So we're really looking at a full year of federally backed mortgage payments being paused, right?
That's right.
So that could be a benefit to the shareholders or to the unit owners, where they have the ability to stop their big mortgage payments, and hopefully they can in return have a little bit of extra money freed up to pay their rent, not the rent because it's not a mortgage, common charges or their maintenance, because there's no law right now that says you don't have to pay your maintenance or your common charges. That's up to the individual building if they want to work out payment plans with people. But as we know, you can't evict somebody, which ties into this whole project.
One thing that I think is interesting about that, though, which we forgot to mention when we discussed the PPP program, is that a lot of underlying mortgages on co-ops, and there are a couple of condos out there that have similar mortgages on the building, although it's uncommon. Often those mortgages say that you need the consent of the lender before you get any further financing. And so before any building applies for a PPP loan, we've recommended that you have your lawyers look over the underlying mortgage documents to make sure that you're even eligible to apply for a PPP loan. And if it does require the lender's consent, that you go to the lender and get their written consent before you apply.
That's a good point. I didn't think of that. That's really good.
That's why I'm here. I got you.
I came up with like laundry room and elderly hours, and you came up with mortgage permission, bank permission. So we're even.
There you go.
Another
thing, though, also about the PPP loans, that was really primarily for co-ops. For condos, sometimes the board's authority to act is restricted when it comes to mortgaging. So usually the board is only allowed to take a mortgage up to a certain amount before it requires unit owner consent. And so if you're in a condo and you want to apply for a PPP loan, you should check that provision of your bylaws to see if the board is authorized to get the loan. And if it requires unit owner consent, then a consent form will have to go out and you'll have to get a certain, whatever the threshold is, usually 2/3 of the unit owners to vote in favor of getting the loan before the board can even apply for it.
Right. The tax protests, which are usually due by March 24th, those were extended now. Those are the tax certiorari proceedings, like the TC 101 forms that we fill out with attorneys to protest the tax valuation on the buildings. That was now extended till 30 days after the New York state of emergency ends. So that's another benefit to buildings right now, having a little bit more time to, get.
Yeah, that's great.
And also virtual notaries. Have you guys been doing a lot of virtual notarization?
So I'm about to do my first virtual notarization this evening. Thank you for asking. I was just reading the regulations to make sure I didn't mess it up.
What do you have? You just have to see the person or hear the person, right?
Yeah.
Do you care to listen to like non-essential and essential construction on buildings and have that stopped? Do you want to hang out for a little bit? I'm sure you'll have other things.
I got nowhere to go.
True. I have you for the next, 2 months?
Yes.
So State Executive Order 202.6 and then the Empire State Development Corporation guidance say that non-essential construction suspended for the duration of the emergency. And the only exceptions to that would be construction needed to protect the health and safety of the occupants, construction work that's necessary to make a site safe in advance of a suspension, construction work that's limited to a single worker, and construction related to utilities or hospital and healthcare facilities, transitional and affordable housing. So FISP, which is the facade inspection safety protocol, it used to be local law 11, now it's FISP program. That's considered to be essential since it deals with a lot of unsafe conditions and repairs and maintenance of the outside of the building and having bridging up and protecting the general public and the residents. So that kind of leads me into another program that is extended, which is it's an amnesty program for the FISP. We're right now, in my last podcast, number 24, was a whole FISP with an architect. They came in and we went over it, but we're in cycle 9A right now, and so the DOB is saying that there's amnesty for buildings that didn't file their cycle 8 buildings, which was supposed to have been the last subcycle C of 8 ended February 21st of 2020. So if you didn't file, now you're available to file without penalty, but there's still going to be a filing fee with that report, and also it doesn't waive any late fees, civil penalties, or ECB fines for not filing the report, and all of those must be paid, including any prior cycles penalties prior to or at the time of the amnesty program filing. So reports, they must adhere. There's new laws that came out in cycle 9. So those cycle 8 repairs that weren't filed that are now going to be filed have to now include the cycle 9 rules, which are additional hands-on inspections for every 60-foot interval of street and public right-of-way facing facades, probe investigations along every 60-foot interval of cavity wall facades, new and increased civil penalties, and the display of facade condition certificates in building lobbies. So just like the restaurants have the letter grades, we're moving. Yeah, we're moving towards that with energy grades. That comes up this year, and then I guess we're also going to be in cycle 9 putting how safe is your building, have you filed safe? There's also new penalties in cycle 9. We went over that, but failure to file is now $5,000. I think it used to be $1,000. The late fees are $1,000 per month. Unsafe conditions that are not corrected are also $1,000 a month. So the city's getting very serious about making sure that everybody files their safety inspections on time.
Well, there are a lot of, after that woman was killed near Times Square earlier, a couple months ago, they've changed a lot of the FISP regulations. Now you need to have bridging up, even if it's just an inspection. They're really doing a lot to make sure that that doesn't happen again.
The city is very good at being reactive.
They are very good at being reactive, yes.
Anytime there's something that happens. And
anytime somebody dies and it's on the front page of the Post.
Yeah, completely.
They act promptly.
I can name probably 5 local laws that came out in the last 3 years just based on that, like gas stove covers, increased inspections, the gas inspections, the facade inspection. I mean, you name it, they're going to
Absolutely.
Is there anything else? Oh, so insurance, the last thing we could cover is like, we're wondering about, and it's so new, we don't know what's going to be covered, what's not going to be covered. So this comes from McCool Risk Solutions, and I've had Ed McCool. Do you know Ed McCool?
Yeah.
Yeah, so I've had him on a few, maybe like 2 or 3 times on the podcast. On the videos alone, he's done a few with me. So I asked him to send me over some information.
Is that a cheap shot at me because this is my first one?
Yeah. So I asked him to kind of give me some information. We preemptively filed for business interruption claims for all of our clients. Not knowing if we would be able, just like you said before, like the revenue I have a few buildings that have salons or restaurants. I have a Soul Cycle in one of my buildings that's renting space from the condo. In Soho, what's going to happen with that? Are they going to be able to pay their rent? Are they going to go under? They're taking the SBA loans because they have the ability to. Are those going to be advanced to them? We're sitting out. We don't know. Like there's
right, sure.
So right now we've put in the portfolio-wide business interruption. I had a call with an adjuster today from one of the carriers that was saying, as of now, the COVID is not a covered loss. As of now, it could change. So we've put them on notice in the case that law changes, and we're just being proactive to.
Yeah, I definitely think being proactive in this case was the move. If there's going to be insurance proceeds to be had, you want to make sure that you're in line to get them. From my understanding about business interruption proceeds, that they're only available in the case of a casualty, or at least this is what my insurance person told me, and that the pandemic is not going to be defined the same way as a casualty, which would mean, a hurricane, some other a blizzard, something like that, which would actually prevent the business from operating. I mean, it seems to me like this is exactly what it was intended to cover, an executive order preventing a business from operating. To me, that sounds like it was ripe for this type of insurance, but the insurance people, clearly, because they don't want to pay out the claims, are taking a different approach. So we'll see how that one comes down. I keep following that because I'm very interested to hear. But it was definitely a good call to have all of your buildings, file now.
Thank you. Workman's compensation. They're saying typically for a workers' compensation policy to cover a claim, the loss must arise out of the course of employment. So when it comes to COVID, it's going to be challenging to claim that is, a covered loss. General liability, a GL policy on subsequent litigation. It might play out if customers can verifiably link their illnesses directly with employee illnesses. For example, property owners could be sued for negligence if you fail to keep your building clean and virus-free by taking proper steps to disinfect the building, leading to residents getting sick. The commercial general liability policy may defend such a lawsuit, but after the SARS outbreak in 2003, many carriers added a communicable disease exclusion, which could exclude coverage. Again, we're seeing reactive. The city goes
right again. Reactive. That's interesting. I didn't know that. Yeah. I don't usually read the insurance policies I'm just sort of aware of what type of coverage we have. And then any questions, I bump it to the insurance broker to help me out because those policies are so confusing. So I didn't know that since SARS. That's interesting and not surprising at all.
Yeah, so they really reactive by closing the services. I was saying it was the
of course.
New York, which is expanding the rights. Environmental and pollution policy. So environmental insurance policies may be designed to include affirmative cleanup, disinfection, and decontamination coverage. Under pollution policies, disinfection expenses are specifically defined, and coverage is only provided for the properties which are scheduled to an insurance policy. Additionally, policies may require an order from a local, state, or federal governmental or public health agency or entity to disinfect the property in order to trigger coverage. Even so, there may be limitations to available coverage for COVID-19 depending on specific policy wording. The federal government's increasing the amount of small business loans available to help companies weather the COVID-19 storm. So that could be also an out there. So that's basically the major insurance information that we got from Ed McCool over at McCool Risk. So thank him for coming on so many times and being available whenever I need him and just giving so much information, just like you. Yeah. But you've spent so much more time. We're at almost an hour probably.
Right, so I get credit for 2 podcasts.
Yeah,
let it be known.
Double credit. A smiley face on your report card.
Oh, thank you.
Do you think we covered everything? We did a lot.
Oh, I'm exhausted from this. Yeah, I think we covered everything. I mean, a lot of the issues that we've been seeing are building specific, and so it's important to check your corporate documents and make sure you're doing everything that complies. And again, boards should be recording any actions that they're taking, through formal resolutions and including those in the minutes, making sure that corporate policy doesn't fall by the wayside, even though these times are crazy. And then I guess we'll continue to monitor the situation. I mean, on the PPP loans, there's a 15-day comment period where lawyers and accountants and any management companies, anybody who wants can comment on it and ask for clarifications. And so I'm sure over the next week or 2, we're going to be seeing additional regulations that help clarify some of the discrepancies in the law. So we'll continue to give you updates. Our firm continues to write advisories and post them. We have a COVID-19 resource center on our firm's website, which is armstrongteasdale.com. We continue to write memos, as do the other departments, the employment department and trademark law. The pandemic's affecting everybody. So it's interesting to see all the other advisories that come out. But yeah, I think this was a pretty comprehensive covering of as much COVID as anyone else can handle. I can't even watch the news anymore. It's too much.
It's depressing and it's anxiety inducing.
It is. But a lot of people have questions, so I think we did a good job covering things. Thanks for inviting me on.
Thanks for coming on.
Thanks for having me.
Yeah, what's your phone number for everybody listening, or do you want to give out your email address or both?
I will give out both.
Okay.
My email address is Schechter, which is SCHECHTER@ATLLP.com. And if you want to call me, my phone number is 212-209-4406. Or you can email Mark and he knows where to find me if you missed any of that. But thanks everybody for listening. Thanks, Mark, for having me. Next time I won't report live from my living room in a sweatshirt.
And I forgot to give out the podcast email address in the beginning. So if anybody's listening still, but it's NYC Real Estate Podcast @gmail.com. NYC Real Estate Podcast @gmail.com. And this was actually fun. It was a terrible subject, but it's
always fun with you, Mark.
I feel like I learned something today. So
well, I learned something about insurance, so thanks for that.
No problem. So we'll see you again.
Absolutely.